Thank you very much. And I never like having anything to do with the last event on the program, but thank goodness we are running a little ahead of time, so before people start wilting on us, we would have finished by then, I believe. And the topic that we will be discussing in this panel is Africa on trial? That's the question, basically. And there should have been, on the program, it looks like there's a panel of 5 speakers, but the last speaker was not able to come. So, but I believe that even his topic will be adequately fed into the presentations that each of the panel members would be making. So I will start off by introducing every member of the panel, and then give with a brief background on each one of them, and then we will start according to the list of topics on the program. So on my right is Mr. Courtenay Griffiths, who is a barrister specializing in all aspects of criminal justice, including criminal law and civil actions against the police and inquests. And he has a national practice here in England and has appeared in a lot of major Crown courts. His appellate court work has included the M25 appeal, and he is a strong believer in international criminal law and believes that that will be one of the expanding areas of the law in the 21st century. And he's currently the lead defense counsel in the landmark trial of the former president of Liberia, Charles Taylor, which is just now drawing to a close. And then the second speaker will be Ms. Elizabeth Evenson. And we just heard her in the course of the interview very eruditely holding her positions. And she's a senior counsel in the International Justice Program at Human Rights Watch. And her research centers on the ICC, and therefore, to a very large extent, she has become an expert, and she monitors the court's institutional development and does advocacy towards the court and its member countries. She has also been focusing on the ICC's investigations of the 2007-2008 election-related violence in Kenya, and Human Rights Watch's efforts to encourage domestic prosecutions of serious crimes in Kenya. And this was quite evident during the course of the interview she has just given. And the third speaker will be Professor Julius Nyang'oro, who is a professor of African Studies at the University of North Carolina at Chapel Hill. And he has done research and has publications in areas of African governance, security, and development. And his research and publications include a political biography on the current president of Tanzania, His Excellency President Kikwete. Professor Nyang'oro has also participated in civil society activities in Africa and has worked with various organizations such as the Society Task Force Mwengo in Harare and Akiba Uhaki in East Africa. He serves as president of the latter organization in the diaspora in the United States. And this NGO deals with human rights and governance issues in the East African community countries. And with the revival of the East African community system, one can imagine that there's a lot of relevant work for them to do. Our final speaker will be Dr. David Hoyle, who this morning we were made to understand is the cause of all this. And that is why we are here. And he's a public affairs consultant specializing in African international affairs. And he's the author of the International Criminal Court, Europe's Guantanamo. The Europe's Guantanamo Bay, and wherein he criticizes rather incisively the ICC. He has also authored a number of other books. One, Darfur, The Road to Peace, Images of Sudan, Case Studies in Propaganda and Misinformation, and Farce Majeure, the Clinton administration's Sudan policy. And he's the author or editor of a number of other publications on African affairs, including Mozambique, A Nation in Crisis, Mozambique, Resistance and Freedom, A Case of Reassessment, and Mozambique, 1962 to 1993, A Political Chronology. So to wind up today's activities, which have been extremely rich, we have for this afternoon also, we can expect and a closing with more rich in contributions from this panel. And we will start off with a Counsel's perspective. Now, is Africa on trial, Mr. Griffiths?
I certainly think it is. Now, what a lot of people don't realize about me is that I was a newcomer to international criminal law when in June 2007 I was approached to defend Charles Taylor, the former president of Liberia. And what I came to realize very quickly was that international criminal law wasn't about law at all. That what it was about was the politics of power and the pursuit of Western interests. And so I want to make, in the short time available to me, 6 points. And I want to be quite provocative because I would like to provoke a debate. Like Braveheart, I've come here to pick a fight. Now, the first point I want to make is this. I have listened with interest to all of the useful contributions made today. And there's a certain word which has not been mentioned by anybody, and that word is profit. And what I'm talking about is the correlation between Western strategic and economic interests and the use of international criminal law to pursue those interests. 2 examples. Number 1, Charles Taylor, my client, told me that he was playing tennis one day and he had been negotiating with Halliburton, the US oil company, about oil concessions off the coast of Liberia. Because I'm sure all of you realize that running around the Gulf of Guinea, beginning in Equatorial Guinea and going all the way around, is a large offshore oil-bearing strata. Ghana's just beginning to exploit it now. Taylor told me Halliburton was offering him a ridiculous rate, and Taylor wanted to negotiate with the Chinese. And he said he got a telephone call from a senior officer of Halliburton who said to him, Mr. President, unless we can make this deal, I cannot protect you any longer. Let me give you another example, briefly, because time is short. In all this debate about human rights violations in Darfur, one thing has never been publicly acknowledged. Darfur just happens to sit on a sea of oil. Bit of a surprise, that. And looking at it from a Western point of view, given Bashir's link with the Chinese, you can understand why the West might want, for their own economic interests, to have an independent Darfur. So we need to get real here and understand what the real dynamic is that's taking place at that fundamental level. You don't have to be a Marxist to recognize that economics is always the substructure upon which these superstructures are built. Second point I want to make is this, and it's a point which was touched upon by Dr. Phil Clark this morning. That is, the referral mechanism at the ICC as a mechanism for securing immunity. But it's also a way of getting rid of awkward political opponents. Let me give you an example. The Special Court for Sierra Leone was set up to try those who had the greatest responsibility for what occurred in that country. Hinga Norman, who was the Deputy Defense Minister, was put on trial at that court, but sadly died. Guess who was the defense minister and effectively his boss at the time? President Kaba. Now, why would you put the second in command on trial and not the man who bore the greatest responsibility? Why not? And the bottom line is this. Apparently, word on the ground is that David Crane, that deranged evangelical former CIA operative who was the first prosecutor of that case, wanted to go against Kaba, but the British government didn't want it to happen. So in was parachuted Sir Desmond de Silva to act as a firewall to prevent Kaba's prosecution. Why? To protect the Blair government, who, contrary to a UN arms embargo, through Sandline and other means, had been breaking that embargo to give arms to Kaba. The last thing you're going to want is a President Kaba in his defense saying, not me, Gov, it was Tony Blair. So, again, no prosecution of Kaba. Now, the third point I want to make is this. Charles Taylor made a speech in mitigation at the Special Court for Sierra Leone last Wednesday. I commend it to all of you, because in it he outlines how it was that the President of the United States decided that it was time for regime change in Liberia, and that there were parallels with what happened to Colonel Gaddafi. Now, my learned friend Mr. Rod Dixon this morning, in relation to Saif Gaddafi, asked the question why there has been this change in attitude by Luis Moreno Ocampo, they call him LMO, between, on the one hand, when it chimed with Western interests, wanting Gaddafi prosecuted at the ICC, the minute the Western project of regime change had succeeded, he changed tack. Saif can be tried in Libya. Well, my cynical mind says to me, if I was Tony Blair, would I want my former mate Saif given a platform in The Hague, free of an interrogator or torturer behind him, to tell us about the dirty gas deals and oil deals he did in order to secure the release of the Lockerbie bomber. Would the West want Saif to be talking about the unlawful rendition which allowed Gaddafi to conduct tortures on behalf of the United States? So, may that be a reason for the change in position? Maybe I'm just being cynical. Now, before I leave, there is 2 points I'm going to make. The first is this. Recall, Taylor was convicted on the basis of him aiding and abetting combatant forces in a neighboring country, knowing that they were committing atrocities. Help me. What did the US do with the Contras in Nicaragua? What did Kissinger do with Indonesia in East Timor, which was mentioned this morning? Now, I'm not saying that to argue that because of that, Taylor ought not to be tried. I'm saying that because when I went to university and studied law, I was told that whether you're princess or prostitute, whether you're the president of the United States or the president of Liberia, the law should be above you. And I want his historic precedent to mean that if it means anything. Final point. On the 26th of April, a West African black man and a judge in the Special Court for Sierra Leone was disrespected big time in that court. That man, a judge from Senegal, who had sat in these proceedings as an alternate judge since its inception, right at the end, attempted to read a dissenting judgment in which, one, he said there had been no deliberations. Secondly, he said that this old international criminal law project was doomed. You know what happened to him? The three other judges got up and walked out even before he started. Then they switched his microphone off and pulled the blinds down on the public gallery. And then last Wednesday it was announced that that judge had been suspended for misconduct because he'd said that as far as Taylor was concerned, he didn't think Taylor was guilty. And that court tried to silence him. Why? Because that wasn't the legacy they wanted to leave. And that's just not good enough if we're talking about the law. Thank you.
Thank you. So according to Mr. Griffiths, Africa is on trial, and underlying all this is profit, and particularly oil. Now, Ms. Evenson, you are going to be speaking on advocating for an international justice system. What do you think can be done? Or what system do you think, the system that we have now, is it as it should be? If not, what do you think it should be? And so as to avoid this one-sidedness. Thank you.
Thank you. Well, that's actually precisely what I want to address, because at the moment, I think the biggest obstacle to work to try to extend the reach of international justice and to build support for the ICC is exactly the very ugly reality which helps to give such currency to accusations that Africa is on trial, that the landscape that the ICC and that international justice stand on is an uneven landscape. International justice hasn't been exclusively concerned with crimes committed in Africa. We saw earlier this week the start of a trial before the International Tribunal for the former Yugoslavia for Ratko Mladic. And before that, also, we've had the use of universal jurisdiction to bring a case against Pinochet, which then set off a wave of prosecutions back in Latin and South America. So even if international justice hasn't been exclusively concerned with Africa, it's nonetheless still true that the application of international justice has been far too selective. Officials of powerful countries or officials of countries allied with powerful countries are far less likely to face justice. One reason I think that the ICC has come in for such harsh criticism is that it was meant to be something different. It's the first permanent court. It has a potentially global reach. So unlike tribunals that were created for a specific situation, for Yugoslavia, for Rwanda, for Cambodia, for Sierra Leone, indeed, it was meant to be a court potentially for all situations. And so it held out the promise that this uneven landscape, that this selective application of the law might be changed, and that the imperative to do justice and to bring those responsible for these crimes to account might finally trump more base, more political calculations. But the ICC hasn't achieved this. And perhaps 10 years is really too short of a time to bring about such a large paradigm shift. Perhaps expectations have been a bit outsized, because you have to remember there are actually two shifts. First, even to get the norm of accountability recognized, that it should be the norm, that's already a huge that's already a huge paradigm shift, when impunity has really been the norm. And then two, to expect to be able to shift political dynamics in international governance. It's a big task. Maybe the future is brighter. But I think that depends on a lot that we're in a position to shift. So it's entirely legitimate that there should be disappointment and even anger with these persistent double standards in the application of international justice. But in my view, the blame doesn't rest with the ICC, and I think that's important to emphasize. It's true there are some situations outside of Africa where the ICC might have acted, say Colombia, say Georgia. I think those were two examples that came up earlier. But the really emblematic sites of impunity, the ones that come up, Sri Lanka, Burma, at the moment, as I mentioned earlier, Syria, those are beyond the reach of the ICC. It's not up to the ICC prosecutor to decide to investigate in those places. And that's because I think of facts that are known to all of you, but simply countries that have not ratified the Rome Statute remain outside of the ICC's jurisdiction unless and until the Security Council unlocks access of the court to those non-states parties. And as I also mentioned earlier, though, the Security Council, while I think its role is incredibly important because it is what gives this potentially global reach, we know its problems. It's a highly politicized body. 3 of its 5 permanent members are not within the ICC. And so between the lack of ratification, blockages at the Security Council, there's going to be a limit to what countries will reach the ICC, and these are not factors that are largely within the control of the ICC itself. But even if this uneven landscape is not the fault of the ICC, it undermines the credibility of the institution as much as if it were. And it's this ugly reality of this selectivity, this uneven landscape, that those of us who support extending the reach of justice must work very hard to shift. So what can be done? No easy answers, no magic solution, but increased efforts at universal ratification, trying to make the ICC a truly global court. Increased efforts aimed at the Security Council for it to be more consistent and accountable in its decision making. It was mentioned the situation in Libya, that there seems to be a foot being taken off the pedal of moving forward with the ICC cases. I would say we see that at the Security Council as well, where there's been almost complete silence on the obligations of the Libyan authorities to actually comply with court decisions. Now, there is an interesting pending proposed resolution before the General Assembly, sponsored by the so-called the Small Five, the S5, and that would recommend that the permanent 5 on the Security Council not use their veto power to block efforts to end or to prevent the crimes that fall within the ICC statute. I think it's an interesting initiative. Of course, it's larger than just a Security Council referral, but could that be a way of trying to bring some accountability to shift some of the landscape that the ICC rises and falls on? But I also think that there is, I said it was largely not within the court's remit to address these factors, but I think there is a role for the court here. Is Africa on trial? I don't think so, but I do think the ICC has been on trial in Africa, particularly among the affected communities where these crimes were committed and where these investigations and these prosecutions are meant to be done in their names. And I think the court's performance has not always come up to scratch in that equation. The next prosecutor will need to do better, better to communicate her mandate to investigate independently and impartially, and therefore to be more resilient to manipulation and to politicization. And the court as a whole can and needs to do so much more to bridge this very large gap between investigations, decision-making, prosecutions in The Hague and the place where these crimes are committed. The better the court does, the more it's seen as a judicial institution, I think it will be more resilient to attacks on its legitimacy and its credibility, and it will put the blame for these double standards where it belongs, which is really with international politics. Shifting these double standards is a long-term game. And in the meantime, I think it's very important, and I think you said it very well, Mr. Griffiths, it's very important to push back at any suggestion that just because the reach of justice is too limited, that means justice should not be done where it is possible. I said before, why Libya, why not Syria? That doesn't mean that there shouldn't be justice in Libya just because we're unfortunately blocked from having justice in Syria. I think there are those who have quite cynically inflated these double standards in an effort to undermine the court's work. And I think here particularly of President Bashir and his allies, this refrain that the ICC is targeting Africa has been used to great effect, not because there isn't a legitimate critique of the international justice system as I've just laid out, but in a much more cynical effort to avoid accountability. And I think this refrain, and many in this room could say this better than I could, but I think this refrain that the ICC is targeting Africa and its converse, that then Africa is opposed to the ICC, really masks much more divergent views within both civil society and governments in Africa. We've worked closely with a loose coalition of African civil society organizations. Many of these groups know that the ICC isn't perfect, but they are still working tirelessly. They are working in their countries to have the Rome Statute implemented nationally, to request arrest warrants for President Bashir so that their governments can't just treat him as if it's business as usual, implementing outreach programs to explain the judicial mandate of the court. And the same is true of many African governments. It's African ICC states parties that have pushed for a liaison office for the ICC in Addis Ababa to better facilitate communication between the African Union and the ICC. Looking ahead, and I'll just leave it here, as I said, these double standards won't be easy to dismantle, but I think it really is the case that a credible ICC and a credible international justice system depend on it. So we can't run from it, we can't pretend that it's not existing, but I think to the extent possible it should not be allowed to stand in the way of supporting efforts to make the ICC that we do have the best that it can be, while also trying to even out the landscape on which it stands.
So, that's a very good note on which to move to the next speaker, because according to Ms. Evenson, whatever are the current weaknesses of the ICC, at the same time, it has a use not only for the rest of the world, potentially, but also for Africa itself, because a lot of the talk about Africa being on trial might not necessarily be a true perception, but rather a disinformation. But so the ICC, is it a strength or a weakness in modern Africa? Is it of any use to Africa? Is it, please, Julius, go ahead.
Or totally useless? Well, actually, it's both, and it's both in a contradictory way. I'm glad Courtenay began the analysis of international politics not necessarily in a classic Marxian manner, but at least recognizing the contradictions inherent in international capitalism today, which we no longer talk about because of the triumph of neoliberalism. It was kind of refreshing a little bit to think about that, which actually saves me from having to go back and make that analysis. But what is important for me is I want to recognize two contradictory processes. The first one, answering the question, is Africa on trial? Yes, it is, and I hope that in my submission I'll be able to demonstrate that. But so is the ICC. So the analysis has to come from both sides of the critique in terms of trying to get to understand exactly the dynamics of the ICC within Africa and the practice of African states in relation to the ICC. I think in order to achieve that objective, the first thing that has to be put on the table is the question is what kind of administration of justice is the ICC attempting to accomplish in Africa? A simple response to that question would be, well, like in any criminal court, whether domestic or international, you are trying to punish the person who has done bad things. In the case of the ICC in Africa, at least superficially, one would make the argument that indeed within the technical confines of its mandate, the ICC is trying to punish people who have done terrible things, the violation of human rights, the commission of genocide, etc., etc. But the immediate second question, which should follow the initial presentation, would be, is the application of that particular kind of justice, punishing in a straightforward manner an individual who has conducted terrible things, is this the kind of justice that is appropriate for Africa at the moment? In Africa, more than any other place in the world, we have a discourse now on restorative justice. And what does that mean in terms of the administration of justice in Africa today? Restorative justice, if you simply take the case of South Africa or Rwanda for that matter, the administration of justice is not simply to get the person who did the terrible things, punishing him or her, throw him in jail or kill him in some respects, but rather an attempt at understanding the context in which these crimes take place. One of the strongest arguments about us not going too hard on Bashir in Sudan, for example, has been the idea that Bashir did not wake up one morning and decide to go after the Darfur people because somehow he identified them and wanted to wipe them off the face of the earth. But rather, Bashir went into Darfur because of the conflict and contradictions within Darfur itself. And the question that we have to confront is whether the reaction and response of the Sudanese government in Darfur was the appropriate one, and whether Bashir should be held responsible for that. Why is that question important? That question is important because, as my friend from Sudan said this morning, the Sudanese folks in Darfur are not going to pack their bags and get on a plane and go deal with the issue of who is right and who is wrong in The Hague or even Khartoum. But rather, these are people who are going to have to deal with each other on a daily basis. So the question is, when you administer a particular kind of justice, is it the one that punishes across the board just because we've been able to establish that you have done something wrong? Or is it something that goes beyond the traditional adversarial system, which is the common law tradition that many African countries have adopted? The literature and research in Africa does suggest that it is important for us to recognize that social relations in communities are important, well beyond the process by which a judicial system takes place. And it is this kind of judicial process that may be the most appropriate in Africa which of course does not fall under the purview of the ICC mandate or even behavior and practice in Africa for the past 10 years. And if indeed that is the case, the application of ICC as an institution becomes the most inappropriate vehicle for the resolution of injustice in Africa, and the failure to raise the secondary question, which is it just identifying and punishing a perpetrator of crimes, but rather what happens after that, because people have to live with each other. The obvious question then, following the general understanding and conversation about the inappropriate nature of the ICC, is if indeed we all understand the discourse on restorative justice in Africa, why has Africa been so quick to adopt ICC? Well, it has been quick to adopt ICC because, I would argue, we have to understand the historical moment when the ICC was being established. What is that historical moment? 2002, but of course the discussions have been going on for about 3 or 4 years prior to that. Africa was coming out of a terrible mess. Sierra Leone, Liberia, DRC, Sudan, Angola, you name it. And we fell, as Africans, into the trap which was identified earlier on of signing on very, very quickly to documents and treaties that sometimes our own lawyers in the ministries of justice do not take the time to read and understand and give proper advice. And for that reason, of course, we have signed on to a lot of treaties which we failed to implement because, after all, if we had taken them seriously and understood them, or at least decided to understand them, we would not have signed on. And for that reason, I would say that we have become victims of our own mental, intellectual laziness, among other things, allowing for us to be then railroaded into the acceptance of the ICC as the instrument for the administration of justice in Africa. But does that mean that the technical realities of the ICC as an instrument for the administration of justice is necessarily bad all the way? If I take the case of the Sudan as one of my last points here, if we may recall, the AU did ask the ICC to postpone, at least for a year, bringing Bashir to The Hague because Africa, within the context of the AU, wanted to resolve the issues, at least to see if there was political room to maneuver, so that Africa could come up with its own solutions. Of course, after having realized that signing on to the ICC was a bad idea. The ICC made a strategic error, I would argue, by refusing to give that breathing space of 1 year. Because when you stop and think about it, that 1 year would have lapsed about a year and a half ago, 2 years ago, which means that if indeed there was a need for Bashir to appear in Hague and for the Africans to be able to come and back the ICC full tilt, we would have had no alternative but to do it if indeed the ICC had given us that opportunity. And so the critique has to be that not only is it the application of the context in which the administration of justice is considered. Yes, but nonetheless, we simply have to understand that on the other side, the lack of understanding of context by the ICC is part of the big problem.
Thank you very much. So the ICC Africa is on trial. The ICC has put Africa on trial, and whereas the ICC itself is really not fit for the purpose it's meant to serve, at least vis-a-vis Africa. That is the gist of Julius's presentation. Now, then in that case, obviously it looks like the ICC's focus on Africa has been quite exclusive, but is it really exclusive? That question is to you, David Hoyle.
Madam Chairperson, thank you very much indeed. The question, of course, actually deals with the ICC's exclusive focus on Africa. And I make the point that it's not just the focus, but it's also really the nature of the focus and the implications of, or the message that is actually drawn from that by people within Africa, some governments and people in Africa, that the entire approach has been one of double standards. And I think it's, very, very briefly, let me actually try to put that into a perspective. We've, of course, heard of the conflict in Iraq and how that should, probably come within the orbit of some sort of international justice, events also perhaps in Afghanistan, etc. But let's actually start with a very, very local point, which is that within our own country, within the United Kingdom, we had a 30-year civil war in the westernmost part of the United Kingdom. And in the westernmost part of Sudan, in Darfur, they also had, and have had, and unfortunately it continues a bit to this day, their own civil war. The British government in our western province, we fought a war against two ethnically based rebel movements. You may want to call them rebel movements. I would actually rather not, but let's call them rebel movements. The IRA and the INLA. The Sudanese government fought a war against two ethnically based rebel movements, let's call them rebel movements, GEM and the SLA. Both sets of rebel movements, whether in Northern Ireland or in Darfur, said that they in fact were waging war against the governments concerned because their communities were ethnically or were economically or politically marginalized, their minority communities. It's a matter of record, and there actually was a 30-year sort of accounting of this, that the British Army responded to its rebellion in the western province of the United Kingdom with a military and security crackdown, which was assisted by locally recruited army and police reserve militias. Locally recruited. It also, of course, augmented that with national forces, but it relied very heavily on locally recruited militia. This is, of course, precisely what the government of Sudan did in Darfur as well. It actually also fell back as part of its counterinsurgency on locally recruited militia. The consequences, the damage done within Northern Ireland is quite extraordinary. And I'll just actually run you through one or two of the things. One of the big issues is that there was, and as we mentioned in the course of today, there was a scorched earth policy in Darfur, that there was massive displacement. There were over 100,000 British citizens displaced in the course, and in fact in the course of a very few years, within Northern Ireland. Many of them were actually burnt out of their homes and their communities. 75% of them came from the minority community at the heart of that particular conflict. Many thousands of people, British citizens, just simply left the province forever. It was the biggest displacement of civilians within Europe since World War II until possibly the events in the former Yugoslavia. We had tens of thousands of British citizens in our own country killed or injured in the course of our civil war in our western province. There were 47,000 separate injuries as a consequence of our civil war, our conflict. 37,000 shootings, 22,500 armed robberies, 16,200 bombings or attempted bombings, and 2,200 incidents of arson. Now, all this was actually within a province 1/35 the size of Darfur. Now, we cannot say that there was a considerable degree of responsibility for all these deaths, for all these injuries, for all this destruction, in effect on both sides of that conflict. The reality, and again, there are lawyers amongst us, and whether we like it or not, is that the highest official, the highest member of the British security forces to be prosecuted, I think, was a corporal in the course of that conflict. Now, in 1997, the British government and its rebels, the IRA, chose to engage in a peace process and chose to end that conflict, the Good Friday Agreement. And what it actually, in effect, did was it chose to draw a line under that conflict. I know this is actually obviously beyond the scope of the ICC, but there's a very, very important point here, which is that the British government and the people that it was fighting within Northern Ireland chose to end that conflict, draw a line under it, and in effect institute amnesty for those who had been involved. IRA prisoners, NLA prisoners, and some of the loyalist militia, that's to say the pro-government militia prisoners, were actually ultimately let out of jail as part of that process. Now, when the government of Sudan has tried that, or would actually take that approach in Darfur, it will be told, no, you cannot do this. When Kenya has actually sought to draw a line under the events following its election, it has also been told, you cannot do this. The British government, however, chose to put peace before justice in Northern Ireland. This is being denied to not just one country in conflict, but a multiplicity of countries within Africa, where the mantra is it's justice before peace. Western Europe, within our own country, within our own civil war, tens of thousands of people killed, peace before justice. Anywhere else, and especially in Africa, it's actually justice before peace. And again, we've actually seen how flawed and how questionable much of that justice on offer can be. So the reason I mention this, of course, is that at the end of the day, the International Criminal Court, the chief prosecutor, has discretion. He can actually make a decision that prosecution within certain conflicts is not in the interests of justice. And that ultimately is a decision taken by the British government as well in the case of Northern Ireland. So having said that, that is actually one of the difficulties we have in perceptions. Image and perception is everything, especially within Africa. Especially within Africa. We interpret this, and I speak as a child of Africa myself, as a focus on Africa to the exclusion of any other examples and to the exclusion of any other comparisons. I could actually go on at a considerable length, but there is no doubt, and I do echo many of the comments made by Mr. Griffiths. There's no doubt that there's a perception, and I'm actually intrigued by it, that the ICC is being used as an instrument of judicial interventionism in order to keep Africa off balance, to keep Africa in a certain spotlight, to actually present Africa as a sort of war-bound basket case. And there's no doubt that there are benefits to certain Western countries of actually doing that. They're able to make far better deals. They're able to actually put far more pressure. And of course, at the end of the day, if you don't do what we want you to do, whether it's in economic terms or political terms or counterterrorism terms, we have the tools to actually bring about your downfall, or to certainly actually put a tremendous amount of focus on you by way of demonization. So yes, there is a exclusive focus on Africa, and in conclusion, the difficulty is you may have got away with that 30, 40, 50 years ago. You can no longer get away with that, and especially in the light of examples not just of Iraq or Afghanistan, but even within the United Kingdom itself. Thank you, Madam Chair.